Hello, everyone. My name is Chris with National Parents Organization, and today I'm here with Don Hubin, who's the director of the National Parents Organization. How are you doing today, Don?
I'm doing well. How are you, Chris?
I'm doing just great. And so today we wanted to cover a little bit of legislative updates from around the country. I know we've got a lot of updates. And what do you have first on the list here?
Well, first on the list is the stunning success in Arkansas. The organization in Arkansas that we worked with and helped, but they took the lead on this, of course, by a long shot, is Arkansas Advocates for Shared Parenting, and they passed a bill, Senate Bill 18, which is in one respect the strongest equal parenting bill in the country. So the way in which it's stronger than the NPO backed bill in Kentucky is that it requires clear and convincing evidence to overcome the presumption in favor of equal parenting. Whereas in Kentucky and in other places where we've worked on legislation, we haven't been able to get that presumption, that stronger presumption. We've gotten a presumption that says by a preponderance of the evidence. So that's a weaker presumption. There's another respect, though, in which the Kentucky bill is stronger, because the Kentucky bill says that there's to be equal parenting, but if there isn't, the court is to maximize the time that each parent has with the children. And so, these are both stunning successes. They really sort of are the foothold for equal parenting. And they've been passed in states that have the citizens have overwhelmingly supported them. In Kentucky, we have follow-up polling, so it's extremely popular. And in Arkansas, NPO worked with Arkansas Advocates for Parental Equality to do polling there that showed that they supported it. And the legislation was passed by an overwhelming margin in both of those states. So this is all good news. Um,
So we have the text here of the actual bill. I'm going to put it up on screen so everybody can see it. But I want to roll through that just a little bit because, like you said, this is really an even stronger bill than in Kentucky, and I think it's important that we all understand why it's stronger and why it may be a model for other states.
yeah.
So here we go. We've got it up on the screen now. It says, "An action concerning an original child custody determination in a divorce or paternity matter, there is a rebuttable presumption that joint custody is in the best interest of the child." And I don't think that's not too different from Kentucky, is it?
That's not too different. The reason that the Arkansas bill could be very short and just say there's a rebuttable presumption that joint custody is in the best interest of the child is that Arkansas, and this is unusual in the states, Arkansas already defined joint custody in a very strong way. Uh, it defines it as both parents have legal custody of the children. That's decision-making responsibility for the children, and that they have, I think the language is something like substantially equal or nearly equal as possible parenting time. So in many states, joint custody is not defined, or it's not defined very strongly. But in Arkansas, it was already defined in a very strong way. And so the bill could just say there's a presumption that joint custody is in the best interest of children. So that part is not really substantially different from what happened in Kentucky. But if you read on, you'll see what's different.
So yeah, we'll go on here, and part B is the presumption that joint custody is in the best interest of the child may be rebutted. One, if the court finds by clear and convincing evidence that joint custody is not in the best interest of the child, and two, if the parties have reached an agreement on all issues related to custody of the child.
Right. So the key words here are clear and convincing evidence. There are three standards of evidence used by courts. The highest is the one that everyone's familiar with from law dramas. That's guilt beyond a reasonable doubt. That's the highest standard. The lowest standard is preponderance of the evidence, which means sort of 50% plus anything, balance is tipped that way. And clear and convincing evidence is between those two. And what it means is, there's got to be a good, clear case. It's got to be obvious to the court. So, and that's the respect in which the Arkansas law is stronger than the Kentucky law. So it's terrific that they got that through the legislature and got it signed by the governor, and it's now the law in Arkansas.
Well, that's fantastic. Yeah. So I mean, some one party, can't just make an accusation of the other party, and they can't just take that as evidence.
Absolutely, you can't just say, "Oh, we don't agree," or "We don't get along." The party that wants to rebut this presumption has to provide clear and convincing evidence that this isn't in the best interest of children. So,
Yeah, and I think that's a good point too. I mean, this is really just this law is not saying that the court has to all the time give custody to both parents equally. It's just saying that that's where the starting point is, and if you want to move from that middle ground, then you have to show a reasonable amount of evidence to convince the court to do otherwise, right?
and the other important thing is that there's deference to parental agreement. So if the parents agree that one parent should have custody, and sometimes that makes sense, sometimes they're living in different states or they're living far away in the same state or something like that. If the parents agree, court should be deferential to the parents unless the parents are doing something that's just outrageous. So that's something that will rebut the presumption, and that's completely appropriate. I mean, parents are the primary rearers of the children. The court is not.
Yeah, and I think a lot of times people forget that if the parents agree, then that's not what we were talking about in changing these shared parenting laws, right? It's when you have a high conflict case where the parents don't agree. Oftentimes, there's false allegations. It's really messy. It's hard for the court to determine who's right and who's being truthful and who's not, and who has motives that may not be in the best interest of the children. I mean, I think that's what these laws are for.
Absolutely. Yep. And the laws actually, we have evidence from Kentucky that the laws actually reduce the conflict. I mean, once you change the game from being winner loser to just, okay, how are we going to continue to parent our children now that we're living apart? You remove one of the primary sources of conflict between the parents.
Yeah, and when you reduce conflict, I mean, there's lots of benefits for the state itself. I think you have much less conflict as far as domestic violence goes. You have less services, social services being used up by the state. And of course, it's better for the children too.
Yep. Yep.
So, what role did National Parents Organization have in the Arkansas bill? Because I know NPO wasn't the primary sponsor of the bill. There was the other group, like you mentioned. What role did NPO play?
So we don't have, MPO doesn't have a chapter. We have a chapter in 26 states now, but we don't have a chapter in Arkansas. But there's a very effective organization in Arkansas, Arkansas Advocates for Parental Equality, that is, their goals are very much aligned with ours. They are, as NPO is, a child focused, research based organization. And we talked with them about how we had been successful in Kentucky in getting the equal parenting bill passed there. And we worked with them to do a poll of the citizens' attitudes toward shared parenting in Arkansas, which showed, as all of our polling has shown, overwhelming support for shared parenting in Arkansas. And that's extremely important in motivating legislators to support this legislation.
Well, yeah, that's fantastic, and we hope that more states, follow the lead of Arkansas and take their text and implement that or some form of that. But what else is going on around the country, Don?
Before we move to other states, I just want to underscore that NPO is enthusiastic about working with other organizations that are child focused and research based and take a solutions approach to this and not just an sort of angry attack at the system. NPO is focused on changing the system, not just on complaining about aspects of the system. So, we played a helper role for Arkansas Advocates for Parental Equality, and we'd be happy to work with other organizations like that around the country. But you asked about other states. So there was a success in Texas. Um, that
But
that
wait a minute, I thought the Texas bill was shot down.
Yeah, well, the really good bill in Texas was shot down. That was House Bill 803. That would have been a strong equal parenting bill. It's one that NPO backed. We made a video. Anthony Brazil, our chapter leader in Texas, made a terrific video that's gotten a lot of views in Texas, and I think that influenced a lot of people. That bill did not make it through the legislation. But sort of flying under the radar, I think, under many people's radar, was Senate Bill 1936. And what does Senate Bill 1936 do? Well, Texas has a standard parenting time order. Now, courts can deviate when that's not appropriate in an individual case, but that's the starting point. That's what we assume it's going to be unless there's some reason to do something else. And previously, I should say actually even currently, That starting point gives the non-residential parent, they have some different terminology in Texas, it's conservator and so forth, but that gives the non-residential parent about 25% of the parenting time, which is fairly typical every other weekend, one evening a week, and part of the summer and holidays and so forth. Um, they also had an extended parenting time schedule that a court could order, which gave the non-residential parent between 40 and 45% of the parenting time. And what Senate Bill 1936 did was to make the extended parenting time one the standard parenting time. Now, it's not quite law in Texas yet, but it is sitting on the governor's desk, and it was passed overwhelmingly in the Senate and the House by 31-0 in the Senate and by 144-1 with a few abstentions in the House. So it's very strongly supported by the legislature, and I have every expectation that Governor Abbott will sign it. And that's not an equal shared parenting bill. It doesn't say that both parents have legal custody of the children, but it is an enormous jump forward in terms of parenting time, which is very important to children's well-being.
Yeah, and I think it's important to point out here, as we're trying to change the system, that change is slow, and you really have to take the wins where you can get them, right? Because I,
Absolutely.
I think this puts Texas in a good position to go back and argue, why are we so close to the center here, but we're not at the center.
Exactly. Yeah. Yeah.
Yeah, great news in Texas, and hopefully the governor signs it soon, and we'll be able to look forward to see some more changes in Texas. I think they had, what was it, 4 different bills that were going through this
Yeah,
year.
yeah, they had a number of bills. That's right. Yeah, they have an organization there that is composed of family law attorneys that, that takes a stand against these bills. In fact, they actually put out a document to their members, the kill bills. Here are the bills we killed, and they take pride in having killed shared parenting bills.
Yeah, if we could only take the profit out of family law, then a lot of these bills would, I think, go through a lot quicker.
All of the money.
It's always about follow the money. Well, speaking about following the money, I hear there's some changes going on in Oklahoma.
So Oklahoma passed some legislation which is a step in the right direction. It's mostly a small step, but one thing it did that was good was Oklahoma used to have a policy statement that said that it encourages shared parenting provided the parents agree to cooperate. And one way of reading that is we don't encourage shared parenting if the parents don't agree to cooperate by having a shared parenting plan. And as we know, it turns out to work best for children on average to have shared parenting, even when both parents don't agree to it initially. So they've actually changed that language, and the language now says they encourage shared parenting. It does say the court can take into account whether there's evidence of their ability to cooperate on issues related to the minor children. But
Okay.
that's not whether they agree to shared parenting, it's can they operate under a shared parenting plan. And we know that there's a huge difference between do the parents agree to shared parenting and are they able to cooperate under a shared parenting plan. So that's a step in the right direction there. Um, the the law does apply a presumption about temporary orders to permanent orders, uh, um, saying that the presumption it applies is an extremely weak presumption. It says if requested by either parent, the court may provide substantially equal access to the children. Now that's permissive language. That's not required language. That's not shall. So it's very weak. But they did extend it to the permanent orders to explicitly make it the case that the court can do that. But if this bill is going to have an effect, it's probably by its requirement that the court uh, include findings of fact and conclusions of law for any decision it makes that both parents haven't agreed to. So if the parents agree on a custody arrangement, the court can just say, we order that. But if the parents disagree, the court has to give findings of fact and conclusions of law. And that's valuable for a number of reasons, because as you know, Chris, often there aren't good reasons to oppose shared parenting. So they'll have a hard time doing that. And also it provides a basis for an appeal. Now, appeals in family law court are difficult. because appellate courts give a great deal of discretion. But if what the trial court says in its findings of fact and conclusions of law for giving sole custody is not reasonable, it gives the parent who's been denied custody a basis for an appeal. So I think that's a step in the right direction. Not a huge step, but still a step.
Yeah, I think I mean, first of all, it boggles my mind that in family law, with things that are as important as our children, that finding a fact is not required in all cases in family law. I mean, it's just quite frankly a failure of our family law system to regulate itself.
Right. It absolutely. And what would be ideal is for a law that creates a presumption of equal parenting, and then the court has to provide findings of fact and conclusions of law whenever it diverges from that, unless it's because both of the parents have agreed to some other arrangement. Because that would really be, it would say to a court, look, we're presuming that equal parenting is in children's best interest. You don't have to provide evidence there, right? But if you award sole custody over the objections of one of the parents, we want an explanation.
Yeah, and I mean, if somebody tries to go back and change that decision later on, whether it's through an appeal or through a new case, I mean, you would then have a basis of understanding to start from, right?
Absolutely. And sometimes the reason for which a court doesn't award equal shared parenting might be something that a parent can correct. So if the parents live far apart and the court says, we can't award shared parenting in this case because of the distance, maybe that parent who was denied custody will move closer, and then they should be able to go back to court and say that barrier's been removed. Now let's have equal custody.
Yeah, absolutely. I mean, and one of the things that drives me absolutely bonkers is, we're talking about these family law cases, is that people assume that things are going to always stay the way they are when this decision is made. I mean, we've had a judge here in Kansas that spoke against the Kansas bill, and one of his reasonings was, well, the father didn't have furniture at his apartment. Well, Dad probably had furniture at his house before he got kicked out of his house, and mom kept all the furniture. And I'm sure at some point he's going to go buy some furniture, but that's not a reason to keep his children from him. I mean, I think on a constitutional level that can be argued, but none of these things are static. And so, parents should be given the opportunity to correct things, and maybe even there should be a grace period of, well, let's reevaluate this in 6 months or something like that.
Absolutely. And, it's not just courts that make this mistake, but parents. You see parents of kids who are like, 6 years old arguing viciously over who has the kids on Halloween for trick or treating. And they are not thinking that, in a couple of years, that's not going to even be relevant. The kids are not going to be doing that.
Yeah.
So, yeah, it would be good if custody arrangements were set in a way that they changed over time or could be reevaluated reasonably. And maybe not going back to court all the time, maybe going to a mediator, and the parents work on arranging it as the kids grow older, as circumstances change.
Yeah, I mean, it's interesting that, in our laws, the federal law requires the states to reevaluate child support formulas, is it what, every 3 or 4 years, right? But there's no same evaluation for parents.
That's right. That's right. Yep. Yep.
Yeah, so and then I guess the last state really to talk about with that had major movement, you had some notes here about Tennessee.
Yeah, but it's not major movement. It started off as a major movement. It started off as an equal shared parenting bill, and it got eviscerated. It got the guts ripped out of it. This is a classic nothing burger. I don't know if you remember the old "Where's the Beef" commercial from some time ago, but you look at this and you say, sort of pretending to be a shared parenting bill, but you say, "Where's the beef?" I mean, it really isn't a shared parenting bill. Ultimately, what the law does is to require that the court provide findings of fact and conclusion of law to support a custody decision unless the parents both agree to it. But there's no other change to it. It originally included a policy statement and an equal parenting provision, and even the policy statement was too strict. Just something saying, we support shared parenting. That was too strong for Tennessee legislators. So. And we've talked about this before, today, Chris. A bill that just says that a court should presume shared parenting is best when both parents agree to it is not a shared parenting bill. It's a deference to parental agreement bill, and courts should defer to parental agreements. So this turned out to be a real nothing burger. It started off well, but it really got it got its limbs chopped off as it went
So,
through.
do you know, are there any plans to go back next year and either amend it or put some better language in it?
So I think in every state where a bill has failed, and we haven't talked about those yet, but in addition to the strong bill in Texas failing, bills failed in Florida and Missouri, Montana, South Dakota, Virginia, and I think some other places. And I think in every state, the advocates, often NPO chapters, are planning to come back at the next legislative session to do this. We have a chapter in Tennessee, and I'm sure they're working on this. And one of the things that it's important to recognize is that one would not have thought that there would be a stunning success in Kentucky before it happened. I mean, Kentucky had a D minus in the 2014 shared parenting NPO shared parenting report card, a D minus, and they went to a straight A. In Arkansas, I can't remember what its grade was, but it was low, and they passed a bill overwhelmingly that is a very strong equal shared parenting bill. And so one of the things I remind shared parenting advocates is, it doesn't happen until it does. And then it happens with great success. So you just have to, keep working at it. We have public support. We have the research that shows this is best for kids. We often have legislators who are supportive of it, and then we're often opposed by the bar association and judges associations, and we just have to keep working at that.
Yeah, the thing that always stuns me from if I look over the country, there's a number of states that are so called progressive, particularly on the east and west coast, and those aren't the states that are having movement in making the laws equal for both men and women.
Yep. I think that's right. It's a pretty interesting phenomenon. Although I would underscore the fact that this is something that's happening at the legislative level, because we've done polling in, for example, California, which one would think is rather radically different from Arkansas or Kentucky, and the polling in California shows overwhelming public support for legal presumptions of shared parenting. So this is this failure is something that's happening at the legislative level. It's not that the citizens of California, who are demographically different from the citizens in Arkansas, don't equally support shared parenting. They do. So
Well, yeah, no big surprise there that the legislators aren't doing what the people that elected them to do, right? I mean, that's common across the country, I think.
right. Yep.
So speaking of failures, we did have a number of bills that kind of made it almost to the finish line, but didn't quite make it across. And I think, I mean, in my experience, at least here in Kansas, is that getting a bill passed into the governor's desk is a rather long and complex process. There's a number of kind of roadblocks that are intentionally put into place, so it's not that easy to pass a bill. And you have basically two sides of a house, and they have to really do the same thing and come and meet in the middle, which getting a number of people to agree on something is rather difficult. So it's not surprising to see that bills will fail, and I don't think that means that they're bad bills or that people don't support them, right?
Or that they're doomed to failure in the future. So it's sometimes there are many reasons that a bill fails, and it's really important what you said, Chris. People need to understand most bills don't make it. Most bills don't make it very far at all. So in Missouri, for example, it made it right up to the finish line, but not over the finish line. And it was a heartbreaking thing. Linda Reutzel, the chapter leader in Missouri, and also a member of our national board, has worked for years on this, and it failed because, I mean, people there said it failed because there was one Democratic lawmaker that was standing in its way, but the Missouri legislature is overwhelmingly Republican, and if they wanted to pass it, they could have passed it. So there's something happening there, and we assume that the Bar Association is working behind the scenes to kill these things. Um, but yeah, we've had a number of bills that have gotten very close. Um, and I think that just means you have a run at it again. And I think these things are likely to go through.
Yeah, I mean, I think that's the important point here is that we're not giving up, and we'll just keep coming back until we get this thing done.
Right. Yep. Yep.
So yeah, some of the states here that I've got notes on are, of course, you talked about Missouri. There's also Florida, Montana, South Dakota, and Virginia.
Yeah. So I don't have details on each of those right now. I do know that Florida has been frustrating because they got a bill through, and the governor several years ago, and the governor refused to sign it, and it had to do with alimony provisions in it, and not with the equal parenting thing. And they've had successes in one chamber of the legislature and not the other, and then in the other chamber but not the first. So that's been frustrating for those in Florida. Uh, but I think all of these bills have been they've they progressed through, and they've sometimes been blocked by one chair of a legislative committee that wasn't in favor of it. Um, so you just need to put more pressure on them. Sometimes, if you have support from the leadership in the legislature, they can determine which committee it goes to. Because sometimes it's not, you know, there are choices that can be made. So that sometimes there will be a child welfare committee and go there instead of going to the judicial committee. And the child welfare committee has fewer lawyers on it, and so you might be able to get things moving there. Anyway, it's really frustrating. I know, and those of us who've been involved with this are frustrated by this, but we're seeing successes, and being close to success means you're more likely to be successful next time.
Yeah, and I mean, we certainly have a lot of other successes to talk about. I think that wraps up sort of our legislative update, but we do have a number of media updates. We've been getting a lot of traction in mainstream media about shared parenting. Why don't you catch us up on that?
Absolutely. And one of the things that's important to remind ourselves of is that though we focus a lot on legislation, what we really care about is changing the way children are raised when the parents are living apart. Now, legislation has a huge role in that, and I don't want to in any way minimize that. But we also want to change people's expectations about how they're going to raise their kids when they are separated. What we really want to do is to reform the norms of separated parenting. Legislation is a really important part of that. But another part of that is just getting people to see that this is what's best for kids. And we've had, in the last few months here, we've had articles in the mainstream media like we've never had before. So, time.com did a long story on this, and featured Matt Hale from Kentucky, who's now on our national board, talking about the value of shared parenting. And in Forbes.com, there was an article written by Ginger Gentile, former executive director of NPO, that talked about NPO and the value of shared parenting and so forth. We've had op-eds published in the Oklahoman, in Parkersburg News and Sentinel, and we had a very nice op-ed published in Virginia in 12 papers, because a syndicate that runs 12 different papers in Virginia picked up the op-ed and published it there. We also had a very nice, very positive story in Rhode Island by a television station there about the Rhode Island NPO award of Champions for Children, I think they called it, or Partners in Parenting. I'm forgetting the name of the award, but they gave it to parents who had initially not agreed to shared parenting, but then as they operated under a shared parenting plan, came to appreciate the value of it for their children. And there was a really positive story on the television station and on their website about this that featured NPO in a really good way. So these things are important because these are the things that will change people's expectations when they go into court. If parents go into court saying, look, we know that shared parenting is best for our kids, our disagreements are between us, we both love our kids, the courts are going to defer to that and allow them to do shared parenting. So that's another really important part.
Yeah, I mean, I think it's important to note. I mean, what I've heard locally is that more and more parents are aware of shared parenting, and therefore, because they even know it's an option. Because I think a lot of people didn't even know it was an option, until we've started to make a lot of noise about it. And now that this thing's getting out in the mainstream media, more and more people know about it and think, hey, that's an option. And so I think more people are agreeing to it. At least that's what I'm hearing locally, which is a fantastic thing. But that doesn't negate the fact that we still need to fight for those that are, I think, most vulnerable in this situation, where you have one parent who is really just trying to destroy the other parent, for all the winnings, let's say.
So really, we need to get to a point where courts are very skeptical of a parent who comes in and says, I want shared parenting. where courts say that, I'm sorry, I want sole custody. We want courts to say why. We know that generally shared parenting is best for kids. You better give us a good reason why it's not going to work in this case. And it's not just because I don't like my ex, why we don't get along. That's not a good reason to not do shared parenting.
Yeah, and I mean, I hope we even get to the point where the judges start holding lawyers responsible for filing these sole custody orders, or or motions without having clear and convincing evidence. I mean, until the legal system starts holding itself accountable, I think you're going to have this is exactly what we have now in the legal system, which is quite frankly most of it's a joke.
Yeah, and there's a lot of game playing and so forth. And look, I really think that if you look at it, from a distance, it's really bizarre that we handle marital breakup when there are children using an adversarial system that requires both sides to give zealous representation of their side and all of that. I mean, it's a horrible system. And what we really need is just a we need parents who are separating to say, okay, we're not going to live together anymore, and here's how we're going to continue to co-parent our children, but not to vilify the other parent in order to gain an advantage in court.
Yeah, I mean, I think in my experience, at least, the world's mostly incentive based, right? And right now there are big incentives for you to fight and keep your children away from the other parent. So until we take those incentives away, then we're not going to change, much of the system on the legal side, at least how family law works, and that's why we're trying to get all these laws passed, I think.
I agree. Yeah.
So we have had some other visibility in the legislature too. We had a number of proclamations made by different states. I know you wanted to cover that. The first one I've got up here is Arizona, and so we have Arizona, and then Kentucky also had one again,
Well,
which I think is great because
Kentucky
even
is doing it every year, and they were the first state to do it. They were the first state to pass the equal parenting thing, and they've done shared parenting day on April 26th, the day in which the Kentucky uh, bill for permanent equal custody was passed, and when it was signed into law, I mean, and then Missouri joined Kentucky a few years later, and then just this year, through NPO's efforts, Arizona, Maryland, and Massachusetts have all declared April 26th to be Shared Parenting Day. So this is terrific news. It raises the visibility of shared parenting. Um, and we're really happy to see this.
Yeah, so hopefully more states can do that. And, if you want help on how to get your state to proclaim April 26th as Shared Parenting Day, contact National Parents Organization and we'll let you know how other states have done it. You'll have to do a little legwork on your own, but we can certainly point you in the right direction.
You
And
won't have to do a lot of legwork because we have we have a database of every state and how you get proclamations issued, and we have a template for people to use. So yes, if you're whether you're an NPO member or not, if you want to get your state to declare April 26th to be Shared Parenting Day, contact us at parents@sharedparenting.org, and we can help you with that.
well, and so what's coming up, Don? What's on the radar, and where do you hope things go in the next 6 months, 12 months, maybe 2 years?
Yeah, so there are a number of things coming up. One of the things that I'm really excited about, and this may be the first time I talked about it publicly, but we are doing a report card similar to the shared parenting report card on child support. Now, the child support system is extremely complex, and we decided that we couldn't grade states overall on their child support laws because there were just too many different factors going in different directions. But as an organization primarily focused on shared parenting, we decided that we could grade the states on the degree to which their child support laws promote or inhibit shared parenting. And let me just give you a quick example. There are 8 or 9 states in which there is no parenting time adjustment built in to the child support guidelines. And what that means is a non-residential parent who's going to be paying child support can see that parent's children one overnight a year or half of the overnights a year, and presumptively they'll pay the same amount of child support. Now, courts can deviate, but it's the responsibility of that parent to come in and say, well, I've got my kids, 40% of the time, and I shouldn't be paying this much because I need money in my household. So there are states that have laws that are very strong barriers to shared parenting. You talked about taking the financial incentive out of this. Well, if there's a huge financial incentive to being declared the custodial parent, um, regardless of how many overnights the other parent has with the kids, then you're going to have fights over who's going to be the custodial parent. There are other states where there are huge cliff effects. So if you have your kids 120 nights, you'll pay a whole bunch in child support. If you have them 121 nights, you'll pay a whole bunch less. Well, that means that parents will fight over whether it's 120 overnights or 121 overnights. Their lawyers will tell them to fight over that. So those are things that are barriers to doing shared parenting. And we want to grade the states on the degree to which their child support laws are promoting shared parenting. We think this will be a very effective tool to work on child support legislation in the states. We also think, as I mentioned earlier, that the states that failed to get child support legislation passed are going to come back and introduce those bills again with more steam behind them, because we're doing additional polling in other states, and we're getting more research that addresses the question of whether shared parenting is best when parents disagree, or when parents um, or when children are very small. We've got increasing research to support what we're saying, and we've got increasing research about public support for it. So we think there will be stronger efforts in these other states. And of course, Kentucky and Arkansas provide wonderful models for other states. And Arizona has a strong shared parenting law, not quite as explicitly strong as Kentucky and Arkansas, but still a strong law. So we have models. It's working in those states, and that will help other legislators decide they ought to support it. And one of the things I want to remind people is, though progress can often be slow, and it can be really frustrating, the winds of change are variable, but they're blowing in only one direction. They're blowing towards shared parenting. And the fact that we're getting more attention in the mainstream media, the fact that we're getting these shared parenting proclamations, and we're getting legislation moved through the legislative process more effectively, those are all signs that the balance is tipping. We're going to have shared parenting in all the states eventually. And I think it's going to start coming more and more quickly.
Well, yeah, I think that's great to remember. And if you want to help out, how can people get a hold of National Parents Organization and help out in their state?
It's really easy. Our website is www.sharedparenting.org. You can email to parents@sharedparenting.org, but on our website there's a get involved. And there are a variety of things that you can do. One of the things that is also new for NPO is we're starting to produce merchandise. I mean, cups and T-shirts and so forth. Um, this isn't a money-making thing for us, really. We don't get a great deal of financial remuneration out of this, but it'd be great to have people have mugs that say "I support shared parenting," or a T-shirt that says "I support shared parenting." If we're reforming the norms, part of that is just person to person communication about the value of shared parenting.
Yeah, certainly showing your local support. I mean, I think it's great to even have something like a T-shirt or a mug because there are a lot of people I don't think that really understand the term, and they may stop and ask you about it, and that'd be a great opportunity for you just to educate one more person. You never know who the person is you're talking to. May be instrumental in helping to change people's
Yep.
minds and get the laws passed.
Yep. Right.
Well, Don, thanks so much for the update. We'll have to do this again sometime soon, and it's been a really informative session here. We've learned a lot about sort of the legislative session so far this year, and I think a lot of sessions are out for the year. I think a lot of them run kind of early in the year, and then they go dormant until next January. So. But we'll hope for another update maybe later on in the year to see what things are going. The things in the mainstream media I think are fantastic. I hope we see more of that. and certainly all the proclamations are great to see too. So thanks so much for joining us, and until next time, we'll catch you later.
Thank you, Chris.